Well, hello, everyone. This is Carol Scott with the National Ombudsman Resource Center. I'm glad to have you joining us for the fourth in a series of orientations for new state ombudsman. This is June the 3rd of 2020, and we're going to be talking about the release of information. Louise Ryan, the Ombudsman Specialist with the Administration for Community Living, will be giving majority of the presentation, and she will then we'll turn it over to Patty Ducaye, the Texas State Ombudsman, and Bev Laubert, the Ohio State Ombudsman, who will share with you an experience or two that they've had when people have asked for information from the program. There will be time at the end for questions. Feel free to chat things in, or hopefully you'll unmute yourself when the time comes and you can speak. And this is a reminder maybe now that if you've not muted yourself, Jan, feel free to do that. Not that I'm going to call anybody out. Okay, so with that, I'm going to turn it over to Louise. And Louise, make sure you're unmuted and share your screen at any time.
Okie dokie. Hello, everybody. Let's see, I need to do one thing. If I can, I've got to move my emails so you don't see them flashing as I speak.
Oh, darn. We wanted to know what was going on.
A lot. So now, let's see here. What I'm confused about doing is I have two screens. So I want to share my screen and share the right screen. Okay, I'm going to share, get the right PowerPoint. Oh, where is it? Okay, there we go. Okay, number one, slideshow from beginning. Okay, do you see the PowerPoint?
Nope. Nope.
No?
Nope.
What did you see?
I just see all of us. When you hit share screen, did you hit the actual share?
I hit share screen.
Yeah. And then you need to click on whichever screen you want and then hit the share button.
Oh, okay. Share it again. Okay. And then share. Select. Okay. Oh, let's see. So, okay. Screen one. Sorry about this here. Okay.
Yep, that's it.
You got it? Okay. You can see me?
Yes.
Okay. I'm going to move the people over there. I'm going to start from the beginning. Okay. How does that work? Am I good?
You are. We can,
okay.
Yes, we can see your next slide too, but that's fine.
Oh, shoot. How do I undo that?
I don't know that I can help you right now. That's fine. Nobody look to the right. Just stay focused on the one in the middle.
How's that? Is that better?
That's even better. Yes.
All right. Okay. We'll get rolling here. Thank you. Okay. So today we're going to talk about disclosure of Ombudsman program records. We're going to go over some general terms and definitions, that'll just be throughout the presentation. So it's not like I'm going to itemize them one by one and then say what they are, but you'll get the sense of them, I hope, by the time we're done. I'm going to talk about what is disclosure in the Older Americans Act and in the Ombudsman Program Federal Rule. Talk a little bit about policy and procedure, but really gonna focus on practice when I'll just kind of turn it over to Ohio and Texas, to Bev and Patty, to talk about their examples. And I think as I go through this, if you have questions, certainly you can put them in the chat box or ask them. I think we're pretty casual. So, but we will have time at the end for questions. All right. So what I hope you'll learn today is to kind of get a better understanding of the difference between disclosure of a resident record for purposes of complaint handling versus disclosure of ombudsman program records, because they're kind of related but separate. I'm hoping that you'll be able to describe what is meant by ombudsman program records and other information, and to think about and to learn about reasons to disclose or not to disclose ombudsman program records, and that you understand that you should have a, if you don't have it, then you should get clear policies and processes in your program. But I'm hoping that you already have those things pretty well spelled out. So as a reminder, I am not an ombudsman, although I was one once. Anything that you email to me is potentially subject to Freedom of Information Act, because I don't have any protections around disclosure as a federal employee. And again, a reminder, ACL does not appropriate funds, and we are part of the executive branch, so we have to be careful in how we talk to Congress. Just reminding you of those things. So some key terms we're going to cover: access, disclosure, records and other information, and subpoena and court order, and probably a few others, but those are ones that I think we see those terms a lot. So just as a reminder, because going back a little bit in history, when the Ombudsman program rule was published and then all of the programs worked to get their policies and procedures in alignment with the rule, I looked at most of your policies and procedures as they were being revised or as they currently were. And sometimes I saw kind of what I would think of as could be confusing when you talk about people accessing your records and start using the term access, meaning people accessing our records, when in the Older Americans Act and in the Ombudsman program rule, we very clearly have the term access to residents, facilities, and records. So I think it's important that you try to kind of keep, when I talk about access, I am talking about access to residents, facilities, and their records. And that's how it's kind of spelled out in the rule and in the Older Americans Act. So I just kind of have what's listed here in the rule in terms of what is meant by access. Now, when it comes to, again, access versus disclosure, again, I'm just encouraging you to kind of keep your terms consistent what's in the regulation to avoid confusion. So the Ombudsman program accesses a facility, a resident, or a record, meaning a residence record or a facility record. And then the program discloses resident information for purposes of complaint resolution, for example. So that's a typical way that your program will disclose resident identifying information, is to make a referral or to talk to the facility staff to get the resident help to resolve a problem. That's a disclosure, right? You're disclosing resident identifying information, and that's a very common practice in resolving a complaint. But then you also get a request for your records, right? So then the ombudsman has to determine what, if anything, is disclosed in terms of the program information, which generally speaking, program information includes resident and complainant identifying information, right? Whether it's a complaint that you worked on or observations, information and assistance, attendance at a resident council meeting. Those are things that are all part of an ombudsman program record. So what you need to think about and review, and Carol, I believe you did give homework for people to review their policies and procedures around disclosure of records? Carol?
I'm here.
Okay.
I just got,
Oh, she disappeared again. I hope, I don't know if that's my computer or yours, but I don't hear her.
can you hear?
You sound good, Louise.
Okay, thanks. Think something on Carol's end. So anyhow, I'm hoping you got that homework. If you didn't, then it's really important that you look at your forms around when you're getting resident consent to access their records and consent to disclose their records. Some programs have the same form with different check boxes. When I was a state ombudsman, we ended up with 2 separate forms, so it was very clear, we're accessing your records. And it was very clear, we are disclosing your information, disclosing your records. So think about those kinds of, in the complaint handling theme, think of those kinds of processes. And then with, and I'll get into this a little bit more, when you think about your criteria to disclose any program information, do you have forms that people put in the request on? Do you have a template response letter, etc.? So what does the Older Americans Act say? And this is long-standing language that it affirms that the ombudsman, meaning the state ombudsman, determines disclosure of ombudsman program information, and the ombudsman is prohibited, and the ombudsman program is prohibited from disclosing complainant or resident identifying information unless there's consent or a court order. And I think that's, well, for those of you who've been around for a little bit, you probably got that one down pretty well. The rule goes into a lot more detail, and there's 3 areas in the Ombudsman Program rule that talk about disclosure. So one is in policies and procedures, that you are required to have policies and procedures around how resident identifying information and Ombudsman Program information is disclosed. Further, in 1324.13, State Ombudsman Functions and Responsibilities, there's 2 areas that talk about disclosure of, or that Ombudsman Program information. In Section D affirms that it's the State Ombudsman who makes those decisions. And then E provides further guidance on disclosure. And then in complaint processing, again, very specific to the resident, there are 3 areas that talk about disclosure of resident or complainant identifying information. So in the policies and procedures part of this, you are required to have, again, a policy and procedure that's consistent with the Older Americans Act, and one that prohibits the disclosure of identifying information of any resident, except for the exceptions are around a resident who can't give consent and who doesn't have a resident representative. So there's those exceptions in the complaint handling part. But basically, the program is prohibited from disclosing information, identifying information, unless there's consent by the resident or the representative, or the disclosure is required by a court order. And ACL defines a court order as a judge's order, not just a subpoena from a lawyer, but an actual judge's order. And I'll talk a little bit more about that later. Okay, in functions and responsibilities for the state ombudsman, it requires the ombudsman to manage the files, records, and other information of the ombudsman program, whether in physical, electronic, or other formats. And that includes of course, the information by your representatives of the office and the local ombudsman entities. Those records, whether they're in your office, whether they're in the cloud in a software, whether they're locked up in a local ombudsman entity file cabinet, those are the records of the Office of the Long-Term Care Ombudsman. And so, you know, you as the state ombudsman retain control over those records. And, you know, and then, what was I going to say? And then, of course, you have your policies and procedures to help your representatives know when they can disclose information or not, such as during complaint handling. So the other part of your functions and responsibilities is that you, again, you have the sole authority to make or to delegate determinations. So frequently as state ombudsman, you have your policies and procedures around complaint processing. And in that, it allows for your representatives of the office to make referrals, right? Or to talk to facility staff. That's a disclosure. And you kind of grant that type of disclosure, for instance, for complaint processing, because it's just a practical thing that you need to do. Okay. So there's that kind of, again, that kind of complaint processing disclosure. And so then, again, the other thing to keep in mind around disclosure more broadly is that, again, the ombudsman has to comply with the strict requirements around disclosure, regardless of who the requester is. So I'll talk a little bit more about who requests records and what does that mean. But again, it doesn't matter who asks. It could be, you know, we've had examples lately of state auditors' offices or your contract monitoring agency, you know, and they say, well, your funding depends on our monitoring you. It doesn't matter who's asking. You still have to go through a criteria to determine if it's appropriate or not to release those records. And many times it's not appropriate, and I'll talk more about that. So part of this gets to you as state ombudsman. I'm hoping you inherited a criteria that will work for you or that you can build upon, but you are to develop and adhere to a criteria to guide your discretion to determine whether to disclose files, records, or other information of the office, right? So hopefully you're learning about what you have. You also have to develop and adhere to a process for appropriate disclosure of information, such as classification of records and identifying an appropriate designee. So for instance, you may have in your policy and procedure such things as, you know, again, for complaint processing, yes, you can disclose in accordance with resident consent, or where a resident can't consent, you know, in accordance with procedures, getting my consent, you know, all of those kinds of things you have ideally laid out in your current policies and procedures. And then you might also have, you know, we share on our website, you know, our complaints by type of complaint, by setting, nursing facility, residential care community, on a quarterly basis. You know, you might say we put up a dashboard. And so that might be some general public information that you always share. And those are examples of a process for appropriate disclosure. The other thing is you do get to do things like take a vacation, or something happens and you have to be away for a while. And so you can designate somebody in your absence to make those determinations about release of records. So like in some states where there's an assistant state ombudsman or deputy ombudsman, they become that person. In states who don't have that, their policies and procedures might say the most senior regional ombudsman is the person who makes that decision, makes those determinations, or it might be that you decide you're going to rotate that responsibility and have some other way to do it, but that you have a designee when you need to be away from the office and not working. So again, on getting to complaint processing, okay, again, with the Ombudsman program being person-centered or resident-directed, that means that you always have to obtain not only consent to take action on the complaint, you need that level of consent, but then consent to disclose or to talk to people or to look at records. That's again, you know, you get consent to look at records, you may need to make a referral, so you're disclosing records or information. So that's all part of disclosure. And then in the rule, it also gets more precise and directive about if a resident can't give consent and they don't have a representative, or their representative is a bad actor, there can be consent to disclose that resident identifying information with you, state ombudsman consent. So you need to make sure you have a process for that. And then if the representative of the office personally witnesses abuse and that resident can't speak for themselves, does not have a representative, that representative of the office can take action and disclose, again, in accordance with your policies and procedures. So I've probably said now 20 times, policies and procedures. So if you have not read through your policies and procedures, I would say that is your #1 homework, to really get to know your policies and procedures and to try to use them. You know, do they make sense to you? Can you use them? Can you go work a complaint with a local representative and see how the policies and procedures work, for instance? So you need to get to know your policies and procedures. Okay, so in figuring out criteria to disclose, again, I'm hoping you have policies and procedures that lay this out. So again, in complaint handling, you know, you're pretty much relying on your policies and procedures to direct your representatives to disclose resident identifying information with consent and for a specific purpose to resolve a complaint. In looking at disclosure of Ombudsman program records, you're looking at it in accordance with criteria that guides your discretion to determine if it makes sense or not. And I'll, next slide, I'll talk a little bit more about this. What does it mean to develop criteria? Here I stole from Washington State because I used this when I was state ombudsman and I found this incredibly helpful. We had a letter, a form letter, whenever anybody asked for our records, we sent them a letter. And part of the letter said, consent to disclosure by a witness, resident, or complainant is not sufficient by itself to authorize disclosure of the Ombudsman program records or files. And then this has the Older Americans Act and then the state program law. And I didn't check, there might be a more revised letter that Washington State has. I didn't get around to finding out. But then it says the state ombudsman has developed criteria to determine whether program records or files may be released. And clearly consent to disclosure by the witness, resident, or complainant is highly relevant to the state ombudsman decision. And the state ombudsman also examines whether disclosure of the program records or files would create a reasonable likelihood of And they have 4 things. So would this disclosure create problems such as retaliation against residents, complainants, or witnesses? Would it intimidate individuals from contacting or assisting the Ombudsman program? Would it undermine working relationships between the program, facilities, and enforcement agencies? Or would it undermine other official duties of the Ombudsman program? So just to give some examples, it might be, the resident, for instance, may say, yes, release my record, release the program record, which has my information in it. But maybe it's between 2 residents, the issue at hand, and maybe that would be harmful to the other resident. Or maybe the resident says, no, I don't want to go to court around this criminal issue. I just can't cope with it. No, don't share my information. Or it could be, the requester is a private attorney and they're filing suit against the facility, and you don't see the merit in what they're doing and feel like it would harm your relationship with the facility or with the state survey agency, those kinds of things. So I think these 4 things are really a helpful way to frame some criteria. The other thing is when a requester wants data, especially if they want a lot of data, you can always offer to share, your statewide data, a regional part of the region, maybe a county, facility level data that is not resident or complainant identifying. Especially that's helpful in preparing for surveys or for surveyors when they prepare, or licensors, that you give them reports that show the types of complaints and were they resolved or not. Case examples can be helpful in some situations. And again, complaint reports that show the resolution, like of our 100 transfer and discharge complaints, 75% were partially resolved, or, those kinds of things can be helpful. Say if it's a reporter or, Attorney General's office or somebody like that. So there's some, I wasn't sure where to put this slide, but I wanted to include this. What do we mean by other information? And this is from the Ombudsman Program Regulation Preamble, and where it's explained that we substituted the term files, which was in the Older Americans Act, with files, records, and other information, to accommodate the increased use of things like digital information, and to also include information obtained verbally and by other means, as well as to clarify that disclosure provisions of the Act are not limited to information that is contained in a case, but could include things like information during consultation activities, or I would add during resident or family councils, or observations. Again, all of that is part of that other information that is not disclosable. And you'll be surprised, you can sometimes get subpoenas from attorneys who say, I know the ombudsman was there on May 12th. What did they see? What did they hear? I want to know. You can get that kind of a subpoena. So who is the requester? Is it, for instance, the resident? When I was looking at policies and procedures that were still in draft form from a lot of states, a lot of times they said, well, if the resident wants our record, we'll just give it to them. They're the resident. But really, you have to be careful. And I really cautioned against that, having a blanket, yes, the resident can have our record, because it's not the resident's record anymore. When you open up a case, you have a program record and it contains resident information, It might even contain copies of part of their facility records or other things, but that becomes your program information. And so you want to put a resident or the representative through the same decision-making criteria. What's the purpose? What are they going to, what are they going to do with it? Are they going to sue someone? Well, maybe that seems like a good idea and you're happy to help. Maybe not. Are they going to take it to the media because they're unhappy with the program? A resident, and again, the representative may have completely different motivations than the resident. I can think of times where there were family disputes. So you had a family member, not the representative, wanting our records because they were going to sue their brother or sister. There's all kinds of odd things that can happen. And they think the Ombudsman program is going to help them out and hand over their records. So you've got to put everybody through the same process. Again, private attorneys, the Attorney General's office, the Federal Department of Justice, state auditor, disability rights, the agency that monitors your program, the media. So lots of people can ask for your records, and you always want to think about what's the purpose. And I don't think I put this in writing. I may add it. You can always say no. Always say no. Start with no, and then see if there's a reason to go to yes. I will say if the protection and advocacy, or what's probably called disability rights, asks for your records and sends a rather demanding subpoena that says we have a right to your records, et cetera, please call me or send me an email, because we are trying to help programs, because ACL also has oversight of protection and advocacy. So we're trying to help work those things out, because there's kind of conflicting regulation between the Ombudsman program and protection and advocacy. So it's a little bit tricky. So please give a holler if the protection and advocacy makes a demand for your records. But basically this whole list, you can say no. And you might make some people unhappy, but you can offer alternatives. So for instance, one time the Attorney General's office wanted, 5 years worth of records from a nursing home. And it was like, that's a lot of work. Can we narrow it down? What are you trying to do? Well, they were just going on a fishing expedition, and sometimes they can't tell you. And when you can help them out, because they're trying to do something good, and same with the Department of Justice, you want to help them out, but sometimes it's also operationally difficult to try to go back and get consent from residents. Even they may have moved on, they may have died, et cetera, et cetera. So, I always offer, reports help. What else can we do? Can we narrow it down in any way? Because I say with many people, you want to be cooperative, and you want, they're trying to do something good, but you also have to be practical and also protective of the disclosure requirements that you have to follow. Let's see, I'm running out of time. They may, when you get these requests, and they may come in the form of a very stern subpoena, and may reference Public Records Act laws, or Freedom of Information Act, or the subpoena says you must give this to me. You don't have to give your records over, even if you get these kind of stern requests. You do not. And if you're feeling like you're getting pressure, please reach out. This is where your legal counsel should be supporting you. We recently had a situation where in one state, the auditor's office was quite demanding about client records. They wanted all the resident records. And unfortunately, the legal counsel for the Ombudsman did not see the light. So we at ACL, we were able to finally get that squared away, and I am hopefully we'll get a FAQ on this on the ACL website in the near future. So again, if you run into trouble, don't feel pressured to just turn it over, call for backup if you need to. A court order. And a court order, and ACL interprets this to mean a judge's order. And we got that interpretation from our legal counsel. And that's another one that I want to get out as a FAQ. But if you get a judge's order, which doesn't happen too often, but it can happen, this is again where you want your legal counsel to maybe ask the judge to limit the request, to seal the records, or to even to reconsider and based on the circumstances to rescind that order. Any of those things are possible, quite possible. But that's where you have to have your attorney to work with you to, come up with what's our solution here. And just a reminder that you are the statewide leader of a very important program, and you have great power in your authority and duties, especially when it comes to accessing residents and their records, and then the disclosure of those or the not disclosing of those records. And sometimes people have a hard time understanding this authority. I know in my experience, the Attorney General's office would get kind of cranky with me when I would tell them no, but a fishing expedition is not enough to try to, comply. It was too much work, and to what end? So, sometimes you have to say no, and it's really, in this circumstance, it's quite often a good thing. But I did want to mention it's really helpful that you have memorandum of understandings, and in the Older Americans Act and the Ombudsman Program Regulation, you're, encouraged to have memorandum of understandings or similar means with a variety of agencies. But it really is helpful when you have these MOUs with some of these requesting agencies like the Attorney General's office or the survey agency or protection and advocacy, because not only does it describe program responsibilities, but that referral process and response to referrals, also, describing how you share information, how they can request information. So with that, I'm actually going to turn it over to, was it
Turn it over to Bev.
Bev going first? Okay, great.
Yeah.
And I can stop sharing.
Thank you so much, Louise.
Sure.
Hi, Bev.
Hi, how is everybody?
Good.
Great. Gosh, you guys, a lot of people on here. So I was asked to talk about a couple of things. Carol, are you sending my stuff out to them, or what? How are you doing that?
Yes, and I was gonna, I can bring up whichever one you want if you want people to look at it while you're talking.
Yeah, why don't you start with the second thing, the second email I sent you with the form that our regional programs fill out?
Hey, hang on.
So when Louise talks about policies and procedures in Ohio, we have rules. We just put out everything in administrative code rules. And so we have a rule about our records, how ombudsmen document, and then what we do if we get records requests. And so I sent Carol an example. So when one of our ombudsmen gets a request for a record, they notify me by sending me that they complete this form and send it to me, and that kind of cuts down on a lot of back and forth questions. So they tell me if there is a case, what the case number is, the date they received the request, the date that the response is requested. So like if it's a subpoena, when they would have to appear or produce the record. And then they mark what type it is, and then they provide a description of what the situation is. And then this is a question that our lawyers asked us to put on, is whether the subpoena, if it was a subpoena, whether it was accompanied by funds for cost of compliance. So they might send a check and say, you know, for your travel to come to the courthouse or whatever. And then the county that issues the subpoena and the county of ombudsman residence. And so we have that on there because sometimes that helps our lawyers say, well, you didn't serve it right, or you should have sent money and you didn't send money, so you need to either do it again or, but let's talk first before you do it, and then they can talk them out of it. And then the description of the ombudsman contact with the person making the request. So did you get a phone call from somebody saying you were going to get this subpoena, or did someone just call and say, I want a copy of my mom's record? So describe what that contact was, including, and we tell them, including, tell us what you said to them, because sometimes we've had ombudsmen tell someone, well, you can't get it unless you send me a subpoena. And I think I've put an end to that, to tell them don't do that, because then they think if they send a subpoena, they're going to get it. And that makes them really mad when I say no. So we actually have this little video that in ombudsman training about it. I think it's like based on the Monopoly theme and the go to jail guy. So we, then we ask the ombudsman, what do you think? And so these are kind of like a hint on our criteria. What are the pros and cons with the request? What's the potential benefit or detriment to the client if we would release this record? So we just kind of get their thoughts about it, and then they email that to me along with the request, and then we take it from there. So then if you have the letter, Carol, we have a standard letter that we send out. It's basically our, as Louise said, start with no. So it's basically a no letter saying that, and we cite the saying that ombudsman records are not subject to Freedom of Information Act or Ohio's public records law. And we say, you know, confidentiality is an important promise that we make to consumers, and an important assurance that we offer them who are often vulnerable and afraid to share information about caregivers on whom they rely. So that's actually an old version because Hillary's not in our office anymore. But then we send a copy of it to the director of the regional program that sent us the request or has the request. At this point, a lot of people have learned to just contact us directly. So then we kind of do it in reverse. We talk to the regional program and say, we got this request, tell us about it. And then we copy it to our chief counsel at the Department of Aging and the Assistant Attorney General who represents us. So then the person receiving it sees, oh, they're pretty serious about this. It's copied to lawyers. So then sometimes those are for general requests. If we get a subpoena, then the first thing I do is email it to our Assistant Attorney General and say, we got this. This is the situation. I'm looking at the record now, and I'll let you know what's going on. And so we make that review. A lot of times the Assistant Attorney General will just call up the attorney for whoever's asking for it or the person who requested the subpoena and say, you know, we're going to file a motion to quash this. What is it you want? And is there another way to meet your needs, or you're probably just not going to win this? So we, again, always start with no. There have been some situations where we have asked, or maybe a court hasn't immediately quashed the subpoena and we actually have to go make arguments. We have a couple of times gotten an in-camera review where the judge just looks at it and then decides whether the record is necessary for the case or not before he rules or she rules on whether to release the record. So what Carol's showing you here is our motion to quash a subpoena. You see that it's back all the way back to 2013, and that was actually the most recent well-written one that I could find, because honestly, we often are able to talk somebody out of a subpoena. So we don't have to go to this length very often, but I like this one because they cite an ombudsman case in California. So it's nice that we're all sticking together and they can find these cases in various states. So maybe someday you'll find an Ohio case. We usually win these. Sometimes we haven't even had to make arguments. The court will just say, oh yeah, we're not gonna make you give up that record. And sometimes we do redact records to provide them. Let's see, let me look at my notes real quick here. Yeah, the other thing I liked in this was our attorney argued that a role of the ombudsman is not to be a witness in civil cases. And I think that was helpful in this case as well. But basically there was a family member suing a facility, and they wanted notes from an ombudsman from a meeting that an ombudsman attended because they were suing the facility. So that's my story, and happy to. And the nice thing is too, you see there, Cheryl. This is the subpoena, but Cheryl Hawkinson, who signed that, is still our assistant AG. She knows our program really well. We've got a great relationship and rapport, and she kind of knows which ones she ought to go argue and which ones not. So it's a good relationship that we have. I fear that she might retire soon, so I'm a little worried about that. But anyway, that's our story. Happy to answer any questions.
Thank you, Bev. And we will be sending out copies of all these with the recording.
Perfect.
So, Patty, what's happening in Texas?
Hi. So Bev, thank you. Bev gave you guys kind of the range of issues she receives for requests for records. And I'm going to talk to you about one example that really was kind of a turning point for us in Texas in terms of developing our policies and our rules. Because what was happening in our state, and we use local ombudsman entities. So we have 28 local ombudsman offices that are generally housed in an area agency on aging. So of the people that I can see your face, so Michael and Janet, do you guys have that structure in your state? Yes, okay. Okay, good. So, so this may be somewhat relevant for you. So we had the great federal laws, and we had a federal regulation that had been implemented for the Ombudsman program related to our records and many other things, but our rules were lagging behind. They hadn't been developed yet. And what happened for us is that several AAAs got subpoenas, and they were subpoenas to the AAA, but for a range of records, including ombudsman records. And so what was interesting about that is that the AAAs felt compelled to respond to the request. They felt legally responsible, and we had the tricky business of figuring out how does the AAA be responsive to a request for records, but how do we carve out the ombudsman program? And what was important about this is that we didn't really have any clear rules that specified how that should have happened and how that should be handled. We just had a state law and the federal law that defined our records. And while that can seem like enough, and it was to work through the problem, it was an important lesson that we had to do a lot of education for the AAA, that they were going to have to instruct those requesters that they could not release ombudsman program records. They didn't have authority to, and they had to sort of carve us out of these requests they'd gotten. And then really there were several in a row for different reasons, but several requests that were pretty broadly made to a AAA, and again, including some ombudsman program records that were requested. There was no inappropriate disclosure. We handled it, but it was a real source of confusion for the AAAs because it wasn't clear to them how they were supposed to handle these questions. And again, they felt really compelled, whether it was a request for a Public Information Act request, which was a state law to release records, or in some cases, a FOIA request that they get because of federal programs and services that they provide at their agency. And so that led us to develop some new approaches to our guidance in our state rules, and then state policies they're more our policy manual. And they now, and I have them and they're available on the NORC site and I have them in front of me, are really clearly indicating and instructing what we call a host agency. That's where the local ombudsman office is in a local office, somewhere in Texas, that they must inform the person who contacts them of the actions they cannot respond to, and basically refer them to the state office of the long-term care ombudsman. So we essentially gave them language to provide a requester that gave them some comfort so that they didn't feel on the hook for something. And we gave the agencies assurance that my response would be in compliance with state and federal laws, so that there was sort of this dealing with anxiousness by an agency, a AAA, that just they felt like it was one of these things where they felt like they were being hamstrung by the operations of the ombudsman program at first. And so we were able to inform them and relieve them or relinquish them of those responsibilities and give them some backup in our state regulations that apply to them, to help them feel like they weren't going to be on the hook for something they felt legally responsible for. So what I'm admitting to you is that we really didn't have good policies, and that problem led to our policies. And you may encounter some things like that as you practice your ombudsman work. The good thing was that by the time that was happening, I had a very good relationship with attorneys at my office. And that's something you can do today if you don't know the people who will be helping you provide legal counsel. Even if it's better to go to them now before you have a crisis, so that you could even do an exercise with an old subpoena that was received. Take a look at something you find in the files, or find one online as an example, and go through the exercise of talking through that with your legal counsel, so that you together can talk through how this would apply in your situation and to your program. I think that could serve you well, so that the crisis isn't there when you have to learn together. I know sometimes you can't avoid that, but it can be a nice way to try and get ahead of it. So that's all I wanted to say, and turn it back to you guys.
Great. Thank you, Patty. Thank you, Bev. Great examples.
Yeah.
I just want to real quickly point you to the NORC website, and when you get these slides, you'll be able to click on this. But many states have sent us their policies and procedures, and so you are welcome to look at them. We have archived anything that was written before the new rules. So these are all rules since 2016. Alaska has a whole chapter on disclosure and maintenance. Ohio has administrative rules. California, in their policy and procedure manual, has a flow chart that is part of their decision tree. And there is a old but still somewhat relevant document called Best Practices Confidentiality, and it's on our website also. Like I said, it is old, but there are examples in there and some language in there that might help you in addition to the criteria that Louise mentioned. And so we have like 3 minutes for questions, comments. I see that Amanda in Idaho had the Bureau of Occupational Licensing request records, and she said no, and they were not happy. So Amanda, it's always hard to say no. And I know I've talked to a couple of people that have received these requests for information, and it really is important that you have criteria, that you have a process, and that I think, Patty, your advice about talking with the attorney ahead of time is spot on, rather than waiting for an actual incident. So anyone want to unmute themselves and ask a question or make a comment? Or any of the mentors want to throw out any piece of advice?
I'll just say quickly that my piece of advice, because I benefited today from being on here, is just reach out to somebody, Louise or the Resource Center or one of us, because I had, just before this call, I had a conference call with a local ombudsman and Department of Justice about, they want some records on a facility they're investigating. And I knew what it was, the answer was, but it was just nice to hear Louise and get kind of bolstered again in our authority. So I just texted the local ombudsman and I said, I'm feeling better about it. Let's just talk, and then we will make the decision of what we're going to give them and what we're not. So it's just helpful to reach out and talk to one of us, or Louise or the Resource Center.
Absolutely. Mike?
No, I appreciated this very much. We had a similar a request for records, and having read the federal regs and so forth, I see that the authority was so granted to the ombudsman, and that's unique. I don't believe any other entity has such authority as the ombudsman has been granted. And yet we had legal counsel was trying to tell us that no, we have to give this stuff up. And my thoughts, and did have a discussion with Louise, and bless her, the fact is, start with no and then find a way to see if you can work it out. I think that is excellent wisdom, and it served us well in this matter here. Once that information gets out, you can't get it back. It's like trying to unspread butter. It just doesn't work. It tears up the bread in the process.
Oh no, we got another one of those kind.
I like that.
I do too. Louise?
Oh, I just thought that Bev and Patty's examples were so great. So thank you. And, again, reach out to your peers. And, I felt like I was more theory, and the practice is so helpful. And I know for some of you, especially in working with your AAAs, where there may be misunderstandings or other, history that, getting some fresh ideas about this, and the idea of doing a practice run with your legal counsel and having a form, having the clear guidance, it really helps to smooth these over. And the stronger that you have practices that you use, and forms, templates, whatever, people do start to understand, and it helps to reduce some of the subpoenas and other stuff that might come your way. So
this is one of these topics that doesn't happen very often. So it's like every time it happens, it's like, oh my gosh, now what? Now how do I do this? So it's not one that repeats often enough that you can go, oh yeah, it's there. So
yeah, and I guess I'd say, in my experience, it was the more visible we were, the more we got. Yeah. So it can become very, gosh, I'd get subpoenas every month. Yeah. Multiple. So yeah, it depends.
Yeah, absolutely. So if, as you're looking through your policy and procedure manuals, if you have any questions about what is in there, feel free to reach out, as has been mentioned, to either Louise or the Resource Center, or to another state ombudsman. If you have not sent us your policy and procedure manual, and would like to do that, we only have about 10 or 12 on the website. We would love to have 53 of them. So having said that, we are at the end of our time. I want to thank Louise, Patty, Bev, for your great information, and look forward to talking to all of you. I will make one final announcement that we do have a new Mississippi State Ombudsman as of today. Her name is Lisa Smith, and Melanie in Georgia will be her mentor, and we will be introducing her through the Friday emails as soon as we learn about her bio and everything. But so thank you all. Stay safe, and we will hopefully see you guys in October at the Consumer Voice Conference and do this live. And if that doesn't happen, then we'll set up a series of orientation. So I'm a phone call or an email away. So everybody have a great day, and thank you. And that's it.
Thanks,
Bye.
Carol. Stay safe, everyone.
Thank you.
Bye.